Good morning. Welcome and thank you for joining us for today's webinar on protecting yourself against EEOC, OSHA, and workers' compensation claims in the COVID-19 era. I'm Jen Ritter-Tomasic, Marketing Coordinator of Events and Proposals at Ward & Smith, and I'll be moderating today's presentation. I'd also like to take a moment to introduce today's presenters, Ken Gray and Will Oden. Ken's practice experience encompasses various areas of employment-related litigation. He advises clients and litigates cases involving all forms of employment discrimination, wrongful discharge, and breach of employment contracts from small startup companies to Fortune 500 companies. Ken is a frequent lecturer on employment discrimination, workplace retaliation, workers' compensation, and wage and hour law issues. Will's practice experience encompasses various areas of employment and workplace-related counseling and civil litigation in both the federal and state courts at the trial and appellate levels. He is also a frequent lecturer and advises clients on a wide range of personnel issues, including Title VII, Family and Medical Leave Act, Americans with Disabilities Act, Age Discrimination and Employment Act, Retaliatory Employment Discrimination Act, and the Fair Labor Standards Act. Again, thank you so much for joining us. Before we begin, I do have a few housekeeping items. We are going to utilize PowerPoint slides during this webinar, and we think it will be helpful for you to be able to see both our videos and the slides at the same time. To do this, you may need to make one adjustment to your view settings. Find the View Options button at the top or bottom of your screen and click on it to see your options. Then choose the side-by-side mode. The slide deck should appear on the left and our videos should appear on the right. You can then slide the separator to the left or the right to adjust the size of your view. If you do have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try to troubleshoot with you. We also will try to answer as many questions live as we're able to during the webinar. If you have a question, please type it in the Q&A box, and I'll do my best to incorporate all questions into the discussion as time allows. Now, I'll turn the mic over to Ken and Will so we can begin.
Good morning. We have done a number of presentations during the COVID-19 pandemic, and we have come to learn that the most effective way for the people that are viewing the webinars is to get as many questions out there as possible, because if you have a question about a certain topic, then most likely other folks on the webinar will have that same question, and it leads to a good discussion about the issues that are real life. These are not hypotheticals. These are situations where people have had these real life questions, and most likely, given the fact that I've answered 3 different clients' questions this morning about the governor's executive order that are virtually identical, I suspect that a lot of people have the same questions that you're going to see in this slide deck. So we'll start off with the very first one, which is a broad overarching question, and then as we go through the presentation, we'll be answering questions that have been submitted that relates to each of these topics. But the first question is, what are my COVID-19 related liabilities under the EEOC, OSHA, and workers' compensation? I'll take the EEOC and workers' compensation portion of it, and will handle the OSHA part of it. So just in general, in regard to the EEOC, the things that we're seeing, a couple of big topics are accommodations. Do we have to accommodate individuals? And the answer in general is it's the exact same inquiry that you would make if you were dealing with somebody with a disability. The ADA, the Americans with Disabilities Act, is what is triggered here. And you have to do the exact same analysis and go through the interactive process to determine if a requested accommodation is reasonable and will allow the person to do the essential functions of their job, and it doesn't create an undue burden or hardship to the company. And the other thing that we're seeing in regard to the EEOC is you certainly have much more latitude than you typically would have for making inquiries about people's potential COVID-19 conditions. And but on the other hand, you cannot make assumptions about people just because they may be in a vulnerable category, such as age, or they may have certain medical conditions that would be vulnerable to COVID-19. You cannot exclude them from the workplace just because they are in a vulnerable category. And so that's the primary things that we'll be talking about in regard to the EEOC. I'll turn it over to Will at this time for the OSHA perspective.
Yeah, thanks, Ken. So first of all, it's good to be seen. And as Jen mentioned, I am one of our employment attorneys. I'm down in our Wilmington office, also maintain an office in Raleigh. In regard to OSHA, what I have seen through all of this, and I've responded to 5 or so OSHA complaints that have been filed in relation to COVID. What I've seen through all this is that, number one, even though OSHA allows you a period of time to respond to the complaint that you receive, the very first thing you should do is pick up the phone and call them and assure them that you are taking the complaint seriously and will be in touch very quickly. The reason I say that is on 2 occasions during this pandemic, I have been able to head off OSHA coming down in person just by simply picking up the phone and saying, we've received your letter or the complaint, and we will treat it with the urgency and seriousness that it deserves. Before the pandemic, that really wasn't necessary. If they were going to schedule an investigation and come on site, they typically gave you a courtesy call ahead of time. But in the 2 instances where I frankly just lucked out, well, the first time I lucked out by calling, the second time I was dang sure to call. You know, what I gathered from that conversation, the first conversation, was they were getting ready to pack up their bags and come on down, even though they had just issued the complaint letter, because the issues that they're dealing with in this pandemic are so serious. So that's pointer number 1, I would say, is make sure you actually move quicker than the deadline allows you. Number 2, so far, knock on wood, in regard to the complaints we have responded to, we've been able to get a closing file letter just after simply explaining to OSHA in writing the steps we have taken to either correct the issues that are present or disabuse OSHA of the false allegations that have been made. And so as of yet, I have not seen any citations come out of the pandemic, but that's not to say there can't be. And so in the world of OSHA, you always start with a discussion of the general duty clause. General duty clause provides that employers are required to provide for their employees a safe and helpful work environment. And OSHA uses that as their toehold, in addition to additional specific regulations to regulate various industries you're in. And so you start with that discussion, and then really whether you're going to be fined or otherwise have to explain yourself really comes down to what the complaint says. But that's what I've seen. Ken, what if anything have you seen different than that?
Yeah, first of all, I think you gave them a very good takeaway, Will, which is jump on the complaint as soon as it comes in and make communication with the folks at DOL so that they don't pack their bags up and show up. The other thing I've seen, and there's a reason that Will's in the Wilmington office right now and I'm not in the New Bern office, it's because Warden Smith had its first COVID-19 positive employee at the end of last week. And so we've taken measures to address that internally. And then yesterday, I dealt with 2 different clients who had their first exposures in the workplace. So the key is, as Will said, you've got to explain to OSHA the steps that you have taken to protect employees. And if you have an exposure, then you have to escalate that. You have to say what you're doing in addition, whether it's heightened cleaning, For example, when we got our exposure, we shut down the New Bern office and had a cleaning crew come in and on Saturday and completely sanitize the entire building. And we're having folks that can work remotely. So, and we're taking other steps as well. We actually instituted a mask policy before the governor came down with his policy yesterday. So there are things that you can do and that you must do, and to show that you're taking this situation seriously, and that you're doing everything you can possibly to protect your employees.
Well, and the other thing I would add real quickly that's been successful is if you don't already have written communications to your employees to explain the steps you are taking, and I mean detailed communications on a regular basis, you need to be doing that so that if OSHA does knock via phone or otherwise, that is something else you have in your quiver to share with them, to show them that it's not just, you're not just verbally telling folks, but they have resources in writing. And if there is a place where those, I know a lot of folks use intranet or Slack or email or other forms of communication, especially now, but if you do have workers, of course, that are back on site, you really need to be posting that communication also in the break room or somewhere else where employees can see it. Because in one case, I did see where, and we were able to get it taken care of, but I did see where an employee tried to argue that they were not aware of the communications because they had missed the informational meetings that were being held in person. And so that employer luckily had other forms of written communication they could share that showed that the employee was in fact aware of the steps that were being taken. In any event, just like everything else in HR or otherwise, document.
Right. In regard to workers' compensation, we haven't seen that many claims yet, but certainly we're going to see more and more filed as more and more people are affected and go out of work as a result of it. And whether or not it's actually going to be compensable is going to be on a case-by-case basis, because how do you know the person got it at work versus got it at home from a relative versus got it at the gas station? And the standard is going to be, is the person more likely to have contracted the disease at work as compared to the general public? And certainly if you're at a office setting, it is more likely that you could get it anywhere out in public as opposed to in the office. But if you're at a medical facility that deals with infectious disease, respiratory issues, then there's a good chance you very well may be exposed to it in greater measures than the general public. Likewise, if you're in a manufacturing facility where the employees are close together and you get multiple employees who contract it and it can be traced back to you got it from a coworker, then it's more likely to be a compensable injury. So those are, but we'd rather things be under workers' comp than under the general liability of EEOC or OSHA. But and there's nothing you can do about it. Does somebody have a right to file a claim? Absolutely, they have a right. Whether or not it's going to be compensable is going to be between them and the insurance company, your workers' comp carrier, and ultimately the North Carolina Industrial Commission. So with that, and I know we've had some questions that have come in already. Do you want to go ahead and tackle some of those, Jen?
Sure. So I think we do have some that relate directly to the discussion that we were just having. One of the questions is for the person at Warden Smith who was diagnosed with COVID, the question was, were they in the office or were they working outside of the work environment when they tested positive?
The person who gave, and I'm obviously not going to say who it is over this webinar, but they did give us permission to tell the other employees so folks would know. But the person was got exposed the prior weekend from a family member, but they were working in the office and they were in there 2 days last week Monday and Thursday morning, and then Thursday afternoon is when they tested positive. So at that point, we had text messages going out, we had phone messages, email messages, any way you can think, people were being notified, and then Human Resources obtained a list of folks that this person was around and contacted those folks and told them to go get tested. And everybody that's been tested has come back negative. So, we had measures in place so that the folks that were there in the office, if they do have COVID, would not spread it to other people. And it appears that those measures were effective in preventing anybody else from getting the disease. So that's kind of what happened with us.
And then one of the other questions related to notification is, will employers be notified if an employee tests positive by the health department or a contract tracing service, or do we need to rely on our employees to provide that notification?
Well, to some extent, you're just going to have to rely upon the employee. Now, I actually went and got tested myself because of this exposure. And when they were asking me the questions prior to the test, they asked me, number one, did I give them permission to notify my primary care physician if the test was positive? And number two, did they have permission to notify the health department if my test was positive? And so they had to have that permission. Now, if the health department finds out about it, it very well may contact employers, and the health department has a lot of power, and the health department can actually shut an employer down if they believe that the employer doesn't have control over the situation and is having too much exposure and too many people testing positive. But there is no requirement that an employee tell an employer. So to some extent, you do have to rely upon them doing the right thing, but you may get notified by the health department as well.
Thank you. I think a lot of the questions that are coming in, we may address with some of the other questions that were submitted previously, but I'll jump back in if not, and hopefully we'll have some time at the end to address some of them if we aren't covered.
Okay, so let's go on to the next prepared question. And I think will take this one, and I'll read it. Are any employees who are receiving COVID sick or COVID child care pay eligible to also claim unemployment?
So the short answer to that is no. While they are receiving that pay, they're not entitled to claim unemployment. And of course, if they're otherwise terminated later or otherwise are separated from employment, they can obviously file for unemployment just like anyone else.
Yeah.
What else do you add to that?
Right. Yeah, they don't. While they're getting the Families First Coronavirus Response Act, either paid sick leave or paid FMLA leave, they can't get unemployment for those same weeks. But after their paid leave runs out and they're not working, they certainly can get it. Of course, also an employer can furlough an employee who's getting the paid leave, and at that point they no longer become eligible for the COVID paid leave, and then could immediately become eligible for unemployment.
Very good. All right, I'll read the next question, Ken, if you'll take that one. So the question and the factual scenario runs as follows. I work in an administrative office whose culture is informal and family oriented, i.e. resists formal structure. Our leadership team has returned to business as usual. Little social distancing, no face masks, full table meetings in the conference room, some out-of-town corporate travel, one-on-one meetings in small offices, no temperature checks / self-checks. Outside clients are regularly scheduled for meetings in the office, etc. I'm the only member of the leadership team who has not yet returned, and there are only 2 of us on the team who have expressed concerns about current office behavior in relation to COVID-19. We have allowed employees to return voluntarily, and about half of the office continues to work remotely due to fear of COVID-19. There is an unspoken expectation that staff will return in phase 3. I feel uncomfortable and suspect other employees will feel uncomfortable as well. How do I, as HR and a member of a vulnerable population, convince the leadership team that we have a duty of care to provide more protections and model more protective behaviors to our employees? And I'll just stop there. The rest is fairly self-explanatory.
Yeah, and the person, so frankly, this person knows what they're talking about.
That's right.
Because the things that they listed about what the company is not doing is exactly what the company should be doing. And I think that in the last paragraph that you didn't read, it says that the person has mentioned that they could potentially face OSHA, workers' comp, EEOC, and even ADA violations. And that person is absolutely correct. And the company, which has provided one mask and one bottle of hand sanitizer to all employees back in May, has not done enough. And what you can do is you try to educate the management team. You can provide them with articles, legal opinions from that folks have written. We've written on a number of those things, but you need to get them educated as much as possible, because if the government does come in, based on what you're telling me, this company is not in compliance, and I feel confident that OSHA would have great concern here. And I'll add one other point, that a court in, I think, Illinois, just within the last day or two, has come down against McDonald's, a McDonald's franchisee, and said that they're not doing enough. And so this got beyond the administrative agencies and even actually got into a lawsuit. And that judge has come down very quickly and said that they've got to do more to protect their employees and customers. So you hope that management will pay attention to these issues before they have to address them in litigation.
That's right. And then, I mean, just to put even a finer point on that, many times HR has to justify the financial reason for the thing that they are recommending. And so hammer what Ken just said about the potential for litigation and the monetary exposure, because yes, we want our employers to do the right thing, but sometimes showing them the way it affects the bottom line or could affect the bottom line is what really moves the needle.
And Ken and Will, a question came in that I think is applicable to this same matter. If an employee notifies the health department of that they're positive, and the health department contacts the employer, will the health department also notify OSHA or the EEOC?
The health department will not notify the EEOC for sure, and it's very unlikely that they would notify OSHA.
Correct.
Thank you. Should we move on to the next question?
Yep. So the next question is, can I test applicants, new employees, temperatures for COVID-19?
And the answer is, of course, yes, you can, and you should. Another way to keep our employees safe and to show that we're taking due care.
Yeah, this is a best practice, and prior to COVID-19, this would not have been something that the EEOC would have approved of, but during the pandemic, it says this is something you should be doing.
Okay.
Yeah.
Let's go on to the next question. Can I test specific employees for COVID-19, but not all employees? For example, we have employees that travel out of the country where our business is located for the weekend.
Okay, so let me answer each question in segments. Can I test specific employees for COVID-19? And just in general, you can test employees for COVID-19. You can give them tests, but not all employees. That part of it, it does make us pause, because you don't want to be discriminatory. For example, if you were just testing folks that were in vulnerable categories, the EEOC would say that's discrimination. Now, can you test all employees in a particular department? Yes, and that's fine. And then to get specific with the question, it says if it's talking about testing the folks who travel either outside the county, outside the state, outside the country, then absolutely that is perfectly fine.
And a question that came in is, if we know that a coworker is traveling out of the state to a high-risk area and then coming back to work, what sort of systems can they put in place to protect other coworkers?
Well, a lot of companies have mandatory quarantining requirements. For example, Warden Smith, I'm getting ready to go to Aruba at the end of July, and I'm going to have to come back and self-quarantine for 7 days. So you absolutely have a right for any travel to require employees to stay at home for a certain period of time.
Thank you.
Okay, so the next question is, can I store employee COVID-19 information in existing medical files?
Sorry, I'm just thinking about going to Aruba now. Yes, you may. You can store employee COVID-19 information in existing medical files. There's no requirement that you create a separate file for that material. Obviously, you need to maintain a separate medical file from the individual's personnel file, because COVID-19 or any other medical condition should not be the basis for any adverse employment action.
And I'll read this one. Can I maintain a log of daily employee temperatures, such as symptoms, results?
And the answer is yes, you may and you should. Again, we want to show that we're doing all that we can to protect our employees. I'll read the next one. Can I disclose the name of a COVID-19 positive employee to health officials?
According to the EEOC, you actually can do that. If you're talking about disclosing it to the health department, you're not required to, but you can do that. I prefer that folks get permission from the employee in writing before you disclose their name, but the government has actually taken a very lenient view on this because they want to prevent the spread of the disease. So I actually went and looked that one up and found that the EEOC says you can do that, but you've got to be very, I'm very hesitant about broadcasting people's names without their permission. I'll read the next one.
Okay.
Oh, go ahead. Go ahead.
Oh, no, I was just going to say we'll move on to the next question.
If an employee does not use the mask as they should, i.e. not fully covering their nose and mouth, what action can I take, and can an employee be fired for noncompliance? So
truthfully, you can take any action you wish to take in regard from a from a disciplinary perspective. You can give them a verbal warning and write them up. Can an employee be fired for noncompliance? Absolutely. Again, we want to avoid the appearance of focusing on a particular class of employees that could end up leading us down the road to the appearance of discrimination or singling anyone out for an untoward reason. But in the final analysis, you can fire someone for noncompliance. And unfortunately, we've had to help some clients with that because some folks really just refuse to follow the rules.
As we go to the next question, I'll add, as Will said, just be careful about, you need to be consistent and not discipline certain people, but not others if they're all in noncompliance.
And Ken and Will, going back to the previous question regarding quarantine, we've had a number of questions come in about that. Specifically, if an employer requires someone to quarantine do they have to, one, pay them, and or two, are they eligible for unemployment?
Okay. That question is actually more complicated than you would think. If it's a non-exempt employee, you absolutely do not have to pay them. Now, of course, non-exempt and exempt, you can allow them to use PTO, vacation leave, sick leave, whatever you call it. And you would pay them in that capacity, but you don't have to pay them for that week that they traveled. I mean, the fact that they're quarantining for a week due to the travel. If it's an exempt employee and they have worked any at all during that work week, then you're going to have to pay them their regular salary, even if you do not have any PTO, vacation, or sick leave to take. So there's a difference between exempt versus non-exempt. Now, if the exempt employee does not work at all during that week they're quarantining, then you don't have to pay them at all. Okay. Was there another part of that question at the end?
Are they eligible to file for unemployment?
They actually could file for unemployment if they're not getting paid. Good luck getting a check anytime soon, but yes, they can apply.
Great, thank you. And so we'll move on to the next pre-submitted question now.
Actually, real quick, I want to ask Ken a question. Ken, is it still the case that unemployment benefits that are granted due to a COVID-related reason do not get charged against the employer's account? Because we're getting a lot of unemployment questions, and I don't want people to worry that their accounts are getting charged if they're not.
That's correct, Will. If somebody is getting unemployment due to COVID-19, it does not get charged against the employer's account, which means it will not affect your unemployment insurance rate like a regular unemployment claim would.
So that's helpful. Okay. So the next question is, if we don't feel that a mask provides enough safety, can we mandate that employees use a face shield and gloves?
Absolutely. And I mean, you can mandate any safety measures that you feel are necessary. The only caveat is if somebody has a medical reason for not being able to use that PPE. For example, some people have latex allergies, and if you're requiring everybody to wear latex gloves, that person does not have to do so, but you certainly can accommodate that person by providing non-latex gloves.
And I'll go ahead and read the next one as well. If an employee has a pre-existing condition like asthma and is in a higher risk category but cannot work from home, what is considered a good accommodation for this type of employee?
Okay, the EEOC, first of all, wants to see that you're engaging in the interactive process and trying to come up with a way to make it so that this person can work. And it may be that we can put this employee who may typically be in a cubicle with other folks in an office, or some other way that we can distance that person from others and minimize the potential exposures. And so each workplace is going to be different, but I mean, it could be putting up plexiglass barriers. It could be putting desks in front of certain walkways, making certain halls one way so that people come in a building or come in a portion of the building a certain way and they keep going, and so that they're not crossing paths with each other. Everybody's heading in the same direction. There are a lot of different things you can do, and frankly, you're only limited by your own lack of creativity. You got to look at your workplace and decide, what can we do so that we can make this situation so that the person can come to work and hopefully not get exposed to the disease. If there's nothing you can do that will satisfy this employee, number one, you better have a paper trail to show that you've engaged in this interactive process. But it may be that you just have to allow well, let me say this. Also, changing the person's work schedule. Maybe if there's a way that they can come in at night and do their job when there's nobody there or less people there, or come in very early in the morning, or can they allow them flexibility so that they can do their work when there's not as many people present. But if you can't do any of those things to the person's satisfaction, then it may be that we just put them on, let them use their paid leave, and then after that, they're on unpaid leave for some period of time. And that period of time will vary for each employer, just like an ADA accommodation request varies for each employer. And the bigger you are, the more likely it is you need to let the person have additional time off as a reasonable accommodation.
Well, and of course, too, going back to the comment about allowing the employee to come in during off hours, I mean, we all need to use common sense. We don't need to do anything that appears to be a punishment for them expressing that they have these issues. And so, for example, if having them come in after hours means in the middle of the night or something unreasonable, we don't need to do that, obviously, unless they ask to do it. Ken tried to do that to me once, and it really made me angry.
But you came in and did it, didn't you?
I did.
Okay.
You were still in your prime then.
Oh, yeah. Okay. Would it be considered discrimination if we agree to keep employees with pre-existing conditions at home, even if they cannot work from home?
And the answer is no. Of course, the way the question is written, if we agree to, implies that this is at the employee's request. And so, no, that would not be discriminatory if we allow employees with a pre-existing condition to stay at home.
That's right. If they want to do it and we agree to it, that's fine. Now, we should not be suggesting that to folks with pre-existing conditions, because that would be discriminatory. And if they can't work from home and there's no way we can now, this is another way you can modify somebody's job. The ADA says that, if they need an accommodation to perform the essential functions of the job, it may be that we can take away more nominal parts of the job that require them to have certain exposures to more people and really reduce it down to the true essential functions of the job. And if we could do that, that's another way to accommodate. But if we can't do that and they can't actually do their job from home, then this is another situation where we may need to allow them to go on unpaid leave after they've used up their paid leave.
Read this one. If an employee is pregnant, should we keep her at home? What if she does not want to come back to work? You want to take that one first, Ken?
Well, and let me take the first question. If an employee is pregnant, should we keep her at home? Not unless she requests it. We certainly should not suggest it to her, because that would be potential discriminatory. Now, it says, what if she does not want to come back to work? I'm assuming that means after she's had the baby. And if that's the case, this would be, as we're going to want to engage in the interactive process and find out, okay, you don't want to come back to work while it's a newborn. When is it that you believe you can come back to work? And if the answer is one that you can live with and put her on unpaid leave until that time, great. But if she wants to be out 6 months, then that might be too long for your particular business, and we may have to part ways. But that's going to be a discussion. It's going to be a case-by-case basis.
Right. And then, of course, generalized fear of COVID does not entitle someone to stay at home, but there are several exceptions, including whether the individual, and the buzzword's escaping me at the moment, but is particularly susceptible to COVID. Is that right, Ken?
Yeah, particularly vulnerable.
Vulnerable. Thank you.
Yeah. And then the last part of that, would it be considered discrimination if we agree to keep just pregnant women at home, even if they cannot work from home? Well, let me take that first piece. Actually, that could be discrimination from the standpoint that men could say, I'm not being afforded the same protection, and the only distinction is gender. So you do have a potential discrimination claim if you do that. So we can go on to the next question, I think, now. If an employee requests specific accommodations, may an employer request medical information to determine that the condition is a disability?
So you certainly can request medical information and a doctor's note to provide you with an opinion as to what restrictions that employee requires. It's unlikely the doctor is going to come out and describe the individual's condition as a disability, but it will certainly allow you the information you need in order to make that determination and whether a reasonable accommodation can be provided. All right, the next one is, can I conduct COVID-19 tests on all employees on a regular basis?
Absolutely, you can. The EEOC, again, this is a medical test, and normally the EEOC would frown upon this, but during the pandemic, it has absolutely no problems with you doing so as long as you treat it like you are supposed to treat medical information, which it means that you keep it in the medical file separate from the employee file, and you don't disclose information beyond what you need to disclose it. And it needs to be protected so that not everybody can get in and see it that does not have a need to know basis.
Moving on to the next question.
I heard that because of COVID-19, audits from entities like the FDA, OSHA, and EPA will have to first be scheduled by these entities, meaning they will not just show up for an audit without having confirmation beforehand that they can enter the facilities. Is this true?
And I would suggest that that is not true. If nothing else, just from the conversations I've had with OSHA recently, those visits do not have to necessarily be scheduled before they show up. And obviously they have the authority to enter your premises. You can of course request a warrant, but you would never want to do that. So the short answer is no, that is not true.
Yeah, I mean, I can tell you that just in general with OSHA, I've heard OSHA investigators talk about they were on their way to investigate one business, and they saw a guy on a roof for a roofing company that was not properly harnessed in. As they passed by, they stopped and they issued a citation for that, business just completely out of the blue. So the government does not have to give you a heads up. Normally they do, but they're not required to. And if they think something's going on, and it could be just because of they got a number of complaints and the complaints are blown out of proportion, they very well could do a surprise inspection.
So we have two more submitted questions coming up related to PPP loans. Would you all like to address those quickly? And then we've had a number of live questions come in. We'll take those in order.
Sure.
Yes, be glad to do that.
Great.
So can you file for PPP forgiveness for more than 8 weeks and less than 24 weeks? For example, can you file for 10 or 12 weeks?
Yes, you can file for a number in between 8 and 12. You're only going to get the PPP amount that you originally applied for, and initially you had an 8-week period to use it all. Within the last 2 weeks, the government has extended that to up to 24 weeks. It's not any more money. It's just more time to use that money in ways that allow you to get maximum forgiveness. And so you can, in fact, if it takes you 12 weeks, an extra payroll to get the maximum forgiveness, then you can apply at the 12-week mark and do not have to wait to the 24 weeks.
And the next PPP question.
So is PPP money going to be taxed as income for the business?
No. PPP money is a loan, and loans are typically not taxable. The government has said it's not taxable. Now, typically, loan forgiveness is a taxable event, but the government has said specifically that PPP loan forgiveness is not taxable. So this truly is free money if you qualified for it. It truly should be a free money grant that you're able to get completely forgiven. Now, the one thing that the government has also said, the IRS, is that you can't take a deduction for the expenses that the PPP money was used for that was subsequently forgiven. And as an example, we all know that businesses take deductions for payroll costs. And so for the 8 weeks or the period of payroll that's covered by the PPP loan, the company is not going to get a deduction for that payroll. You'll get a deduction for all the payroll outside of PPP, but not for the loan money that covered that particular expense.
Thank you both. All right, are you ready for some rapid fire live questions?
Sounds good.
All right, let's go. So the first one is, if an employer has employees who are older than 65 and one of those employees wants to return to the office, and business is a non-manufacturing business, is it correct that the employee must be allowed to return to the office and cannot be excluded due to their age, even though they are in a higher risk category according to CDC guidance?
That is a true statement. You cannot bar them from employment just because of their age. That would be, if you did, that would be textbook age discrimination.
The next one is for Will. Can we post our COVID protocols in our payroll system document center and set it as a required doc for employees to acknowledge? Will that suffice the notification you spoke about when you were saying notices should be posted in the break room and things like that?
Yes, absolutely.
Okay. So the next one is, are there any guidelines for documenting employees that test positive?
Well, the guidelines would be that any record that you generate because of that should go in the medical file as opposed to their personnel file. And you certainly are going to need to make sure you have the protocols in place, because that employee does not come back into the workplace until, and I'm going to say until blank. What is it that your company is requiring? And let me just say, if the answer to that is, well, I don't know, we haven't decided yet, then that may need to be the first thing you do after you get off this webinar, is to decide what you're going to do. Because as I said, Warden Smith had their first exposure on Thursday. I had 2 companies call me yesterday with their very first exposures. So it's happening. More and more folks are having workplaces that, even though they never thought they would have exposures, are doing so. So what is your plan if you do have an exposure? And I think the best practice is that you require the person to have a negative test before they get back. And one of the questions we see is, can we require a fitness for duty note or a doctor approving them to come back to work for somebody that's tested positive? And the answer is absolutely, you can. So you need to have a strategy in place for what you're going to do when that person is ready to come back. And if we're going to allow them to come back, and typically 72 hours, 3 days without symptoms, and is one standard that folks use. And I even know of one employer that requires 2 negative tests before they allow the employees to come back. And as long as that's your policy and you got that in writing, and you treat everybody the same way, you should be fine.
With compensability with workers' comp, why is this disease any different than another virus? For example, the flu.
So Ken, you and I talked about this a little earlier yesterday. So the idea is it could be considered an occupational disease, right? Because depending on the type of business that you operate, if it's the type of business where employees are in close quarters with one another, manufacturing business, any other close where social distancing is not really practical. There's an argument that can be made that employees who contract COVID-19, arguably while from the workplace, that would entitle them to compensation for an occupational disease. Just like asbestosis or silicosis or any other occupational disease catch-all under the Act. Ken, what else would you add about that?
Yeah, and it really is going to be a case-by-case basis. For example, the person that was Warden Smith's exposure, she got the virus over the weekend from a family member who subsequently tested positive. So that had nothing to do with work. So she obviously wouldn't have a claim. Now, let's say somebody else tested positive in our office that she had been around. Well, if that person's been out and about, how do we know that they got it from her versus they got it from John Q. Public? I mean, you don't know. So it would be a proof situation. And frankly, in a law firm, you're not any more likely to get this disease than if you were in a grocery store or just out in public in general. However, in medical facilities that deal with COVID and in places where people are typically closer together than the general public would be, I mean, for example, we've seen a lot of exposures in the meat processing plants. And so those folks would potentially be able to have a workers' comp claim because typically you're not standing side by side, shoulder to shoulder with individuals in the general workplace. Now, if you're riding public transportation like in New York or DC, and you're obviously likely to get it just in that situation. So it comes down to a case-by-case basis and whether or not the person can prove they got it at work.
Likely, I mean, I would think likely if the person files a workers' comp claim in a situation like Ken just described, their case is not going to be necessarily just dismissed. It will likely have to be settled in order to make sense of the situation financially from the company's perspective.
Thank you both. The next question is Warden Smith providing masks for employees, and what is the best practice for that?
We'll just say,
going to show you.
Yeah, yes, we are. And it is absolutely like burlap. It is terrible. And, but it does its job.
Yeah. Actually, Warden Smith adjusted his policy. We adjusted it yesterday before the governor came out. And basically, we're saying that when you leave your car to come into the building, you need to have your mask on. When you're in common areas and not able to social distance 6 feet, then you need to have your mask on. If you're sitting in your office, you're fine. You don't have to wear your mask. If you're in a conference room and you're 6 feet away from the other people, you don't have to wear a mask. And if there's a medical reason that you can't wear a mask, then we will, grant exceptions. But, and that's typically very consistent with what the governor's executive order has said. It is, as you know, requiring, if you're out in public to wear a mask anywhere in North Carolina, if you can't social distance. Now, the problem with that is there's already been a handful of sheriffs that have said we're not going to enforce that executive order. So that is absolutely a mess. But yeah, it is definitely a best practice, and it's a pain. I know it's not comfortable, but if folks cannot be social distance, then they should be wearing a mask at least through phase 2, which will go at least another 3 weeks to I think July 17 or so.
Right, and so the next question we've touched on throughout the discussion, so I'd like to read the question, but also include a comment that someone said. So The question is, do you recommend using daily health assessments before employees go into the office? If so, how do you administer if their preferred method is self-check? And then a comment that relates to that question is this attendee was told not to record employees' names and temperatures by another law firm.
Okay. All right, there's several different comments. Let me go with the very last one about not to record names and temperatures, and that's fine. You don't have to do that. In fact, I have told people you do not have to do that as well. If you do, it's evidence that you are definitely trying to institute a best practice. Because the one thing that can be problematic is I've had clients say, well, we require folks to come in and get their temperatures checked. Well, lo and behold, they did for about 2 days. And then after that, the temperature gun has sat in the same place for several weeks. And they didn't do temperature checks. And so having the log is evidence that you've actually continued to do so, but you're not required to keep people's information. So, but you need to be able to show that you're continuing to do that practice. In regard to the screenings, I've been in medical offices that before they let you in the lobby, they're taking your temperature, they're asking you the series of questions. Have you had a fever? Got a dry cough? Have you been, shortness of breath? And have you been around anybody that you've known to have COVID? That is perfectly fine. Instead of having somebody there at the entrance to do that every day, you can basically give employees, here's the expectations. If you have any of these symptoms, you need to stay home, or you need to call your supervisor and let them know you're having this symptom, and we will most likely have you quarantine until you're able to show that you no longer have that symptom.
Thank you. And we touched on this briefly earlier too about employees testing positive. If an employee tests positive, can we put them on furlough even if we had not planned to prior and have no other employees on furlough?
Say that one more time, Jen. I only heard the last.
Oh, sorry. If an employee tests positive, can we put them on furlough even if we had not planned to prior and we have no other employees on furlough?
Okay, that's a very interesting question because technically, due to DOL guidance, we know that if somebody's getting entitled to get Families First Coronavirus paid sick leave due to having COVID, which is go for 2 weeks, if they get furloughed, then the benefits stop. However, if you're furloughing them solely because they tested positive, then that likely is to trigger the anti-retaliation provisions in Families First, and I would say that would be a violation of the law. So in other words, you would want to be able to prove that there was a documented reason that you needed to furlough this person that's unrelated to the fact they've got COVID. And I think just doing it because they got COVID is problematic.
There is a question, and this was earlier in our discussion, and Ken, I think at one point you said a 7-day quarantine, and this attendee asked why a 7-day quarantine. They thought it was a 14-day quarantine.
7 days is what our policy is at Warden Smith. Now, the interesting thing is we are actually, once we got the first positive test, we have said that except for folks that we essentially need in the office, we're asking everybody else to self-quarantine for 14 days. So I think the difference is having a positive versus not. Like if I go travel and come back, we don't have a positive test. And so it's fine for me to wait 7 days because now, is it possible I would have symptoms? Yes. I mean, I could be asymptomatic and still have it after 7 days, but you got to draw the line somewhere. There's not a legal standard. I mean, the health department has told some people 5 days. They've told other people 3 days. They've told others 7, 14. It really is across the board. So I think when we looked at it, we decided that 7 days would be a reasonable period. Now, if the person visited a country or went to an area that's a hot spot, we potentially could extend that to a full 14 days.
Thanks, Kim. So the next question is again related to the days you should quarantine and responsibility to let employees know about issues. So the question is, we had someone who visited the office over 3 weeks ago who tested COVID positive and just let them know today. They think they got it on vacation, which was a week after their visit, but they're not sure. It's been beyond 14 days. What is the responsibility to let their employees know? So it's a private business, a customer or client entered the business. They called and said they've tested positive. What should they do for their employees?
But we were notified after 14 days.
Yes, it's beyond the 14 days.
My personal opinion is we should let the employees know. There's no, I just believe in more transparency. I think you cause less panic that way. And I think employees would want to know, even if it is beyond 14 days. I would just, my personal opinion is you just pass along what you know.
And I'm going to start off with a position that may sound different, but I'm going to agree with Will.
Say that again.
Yeah, I know. I said that's unusual, but nonetheless, you know, I am one that would like to not stir up a hornet's nest when you don't have to. However, I think you got to look at, well, let's say we're in a 1% situation where it could turn into a real mess. And it does in fact do that, and you didn't disclose that information to folks, that's going to look very bad for the employer. And I think you're better off, as Will said, being transparent. And my opinion on this has shifted over time. But I do believe that you're better, and the government likes to see that transparency. And so if it's like, well, we knew about this, but we just didn't want to get employees in an unnecessary panic, they don't like hearing that response. They want you to let people know. You don't have to, but I think a better practice at this stage would be to let people know and then to address the concerns and explain what you're doing. You know, this is a situation where you really don't have to do anything if the person wasn't there for several weeks. And I mean, it's not like the virus has gone on, but I think you could let people know. Folks can go get tested. It's really easy to get a test nowadays. I can tell you what I did. You can make an appointment at CVS. You can do it online. You don't even have to have a doctor's note. And typically when you go online, you can make an appointment for that day, the next day, or the day after tomorrow, 3-day window. And we got on the website around dinner time Thursday night, and I'd had to go to probably an hour and a half away because most of the spots were taken at that time. But the next day there were 30 spots available. They do it in 10-minute increments. And I made an appointment, gave them my insurance card over their secure line, and then I pulled up at my designated time period. There was one car in front of me in the drive-through. I was in and out of the drive-through even after waiting for that one car in less than 15 minutes. And it's a self-test, a regular Q-tip, and the guy instructs you how to do it through the drive-through window. Very easy. And I had my test results back in 40 hours, so under two full days. I got back at 7:06 Sunday morning. So it looks like LabCorp is actually working 24/7 to get tests turned around. So it's a lot faster than when we started back in March.
Great, thank you. And for everyone on the call, we are over time, but Ken and Will have agreed to take a few more questions, so we'll just keep rolling. The next question is, does the new North Carolina mask mandate apply to office settings? This employer is 100% office and doesn't have anything to do with manufacturing.
Okay. Well, there are various categories in the, and I'm pulling it up right now. Basically, it is suggested, yes. Now, mandated by the order is only a certain categories, and I'll just start off and read them. Retail businesses, restaurants, in-person care, such as hair salons, grooming, tattoo businesses, in child care facilities, day camps, overnight camps, state government buildings, transportation, such as airports, bus, train stations, and stops. It also, it says this does not apply to traveling home with household members or friends in their personal vehicles, but does apply to ride share, cabs, vans, shuttles, even if the vehicles are privately owned, you know, such as Uber. High density occupational settings where social distancing is difficult, such as manufacturing settings, construction site, agricultural settings, in meat or poultry processing plants, long-term care facilities, other healthcare settings. So that's, you know, essentially any doctor's office or clinic or hospital. So those are the businesses that are required. It is a best practice to do it anytime that you cannot social distance. And in those various businesses that I just read, if you can social distance, you don't actually have to have a mask on. Even though the governor would prefer that you did, you're not required to. If it says you're required if you cannot social distance.
Thank you, Ken. I'm going to sort of skip through because some of the questions I believe we've already answered. This is a good one about separating employees. How do we handle employees who have asthma who cannot, because of the nature of their work, be separated from others? For example, a nurse who sees patients.
In that situation, I mean, you're just going to have to give them as much PPE as they can have. You know, you would need not only a N95 face mask for that nurse, but also probably the shield that goes around as well. They need to be gowned up. They need to be gloved up, and you need to make sure they have adequate access to the PPE. And if that's really, you know, pretty much what you can do for a nurse that is hands-on, that has these responsibilities. I mean, virtually all medical facilities now have the thermal temperature takers so that you don't have to actually touch the person to get their temperatures. You try to do as much as you can social distance and not get and to the extent you have to get close to the person, you do it as quickly as possible and get out. But some folks are going to have to, you know, if they're not willing to assume that risk, and then we're going to have to figure out some other way to accommodate them. And it may be that the only way to accommodate them is just give them time off until hopefully we can get, you know, them more comfortable with the situation.
So real quick, Jen, we had a client text me a question, and I just wanted to cover it before I forgot about it. So,
Sure.
how do we decide whether a COVID-19 case should be recorded on OSHA 300 log? And so the answer is, 300 log, you're supposed to record, should write down recordable illnesses, but that's only if the worker is infected as a result of performing their work-related duties. So like Ken mentioned earlier, it's kind of a proof thing. Hopefully, we have a little more information from the employee in regard to where they believe they were exposed. But frankly, I would, discretion being the better part of valor, I would probably, if we believe it was caused by exposure at work, I would record it. So I just wanted to cover that before I missed it.
Thank you, Will. All right, I think we have time for one more question. So the last question for today is, can a COVID-19 diagnosis be covered under short-term disability?
I think you broke up just a little bit. Did you say, can a COVID-19 diagnosis be covered under short-term disability?
Yes, correct.
It can. I mean, that's going to be between the employee and the short-term disability carrier, because it may depend on how severe the symptoms are. For example, if I'm out of work because I test positive for COVID, but I'm asymptomatic, then I seriously doubt short-term disability is going to say I have any disability. But obviously, if I'm hospitalized because of it, then that is clear, I'm clearly disabled and should be entitled to STD. So it depends on the severity of the conditions and how the STD carrier views it.
All right, great. Thank you so much, Will and Ken. And for those of you in attendance following the webinar, you will be sent an email with a list of articles related to the issues discussed today and other helpful information. We also will make a recording of the webinar available. Thank you so much for attending. You all had a ton of great questions. I was able to track them. I'll pass them along to Ken and Will following today's webinar. I think a lot of them would be great for the creation of an article on our part, so keep an eye out for that on our website. We appreciate you taking the time to join us today. I hope you were able to take some of the information you learned and apply it to your own business. Thank you again, and that concludes the webinar.